Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to look at a case that addresses the issue of just how wrong does a judge, or in this case a jury, have to be before a court can review that. So this is an appeal on the grounds of unreasonable verdict, which is not saying that there was an error of law in any fashion. It's just saying that the verdict itself is bad. That's a tough ground of appeal. And, I've won on this issue on an appeal, but it was essentially a situation where the judge had gotten the evidence backwards. So the question for the court here is going to be, how wrong does a jury have to be before the court is going to overturn it? This is the case of the Queen and Yebes. I'm probably mispronouncing that, but Y-E-B-E-S. Unfortunately, these cases do not come with a pronunciation guide. But let's dive right in here. So we have... the appellant was found guilty before a judge and jury of murdering his two adopted children, so it's not a happy story. He appeals to this court on the ground that the verdict should be set aside, pursuant to section 613 sub, you probably don't care, of the Criminal Code, which enables the Court of Appeal to allow an appeal against a conviction where it is of the opinion that the verdict should be set aside on the ground that it is unreasonable or cannot be supported by the evidence. The issue before this court, then, is the proper interpretation and application of section 613 sub, and it continues. The appellant, Thomas Yebes, a hairdresser, and his wife, Elvira, lived in the municipality of Surrey near Vancouver with their two daughters, one born in 1971 and the other in 1973. For some time, Mr. and Mrs. Yebes had been concerned with the plight of young children in the poorer countries of the world, and in 1977 they began lengthy procedures aimed at the adoption of two Chilean children. In 1979, two boys were brought to Canada to reside with the Yebes family with a view to formal adoption. One boy, named Gabriel, was born in September 1974, and the other, Yurko, brackets Tommy, in September 1975. The boys, it appears, did not fit as readily into their new home as had been hoped. Miss Yebes complained of difficulties with the boys because they would not accept and comply with the rules she had established for the family. Mr. Yebes thought his wife was too strict in her management of the boys. These differences led to increasing domestic conflict and, in July 1981, both Mr. and Mrs. Yebes sought the assistance of a psychiatrist. Professional assistance did not, however, resolve their problems. In September of 1981, at the time that the boys were formally adopted, Mrs. Yebes had reached the stage where she could no longer tolerate the boys in her home, and the couple agreed to separate for a period of 3 to 6 months. Mrs. Yebes remained in the family home with the two daughters, and Mr. Yebes moved with the two boys to a rented townhouse in a housing development a short distance from the family home. Mr. Yebes assumed responsibility for the maintenance of the boys and for paying the rent on the townhouse, the mortgage on the family home, and the utility bills. In addition, he saw to the care of the boys, preparing their meals, ensuring they attended school, and arranging for daycare when he was busy at work. Mrs. Yebes drew upon her savings to maintain herself and the two girls. Throughout the separation, the entire family continued to meet. There were family dinners and visits, but there was little progress toward a complete reunion, and both Mr. and Mrs. Yebes were worried and concerned about the situation. It seems that they both wanted to end the separation, but Mrs. Yebes was apprehensive about the boys. She did not feel that she could manage with them in the family and expressed the wish that they be readopted. On January 28, 1982, Mr. Yebes made inquiries regarding readoption, and upon learning that there would be delays and difficulties, asked a family support worker to give him a letter saying that the boys could not be readopted. This, he explained, might persuade Miss Yebes to accept the boys and allow the family to be reunited. The period of separation was approaching 6 months, and Mr. Yebes admitted that he had to move back soon with his wife because the lease on his townhouse was going to expire at the end of February. This was the state of affairs on February 23, 1982. According to the evidence, Mr. Yebes and his wife had planned a supper for the whole family at the townhouse that night. Mr. Yebes picked the boys up at the daycare center at about 6 p.m. and took them home to the townhouse. Mrs. Yebes and the two girls arrived at about 6:10 p.m. The family had supper at about 6:30 p.m., and then Yebes and his wife went to the bedroom and talked for half an hour about the domestic situation they were facing. Yebes described the conversation with his wife in his testimony at trial in these words. "I told my wife that we have to come back together. The reason for it was I told her that financially we cannot stay separate. I could not support two households for much longer. I told her that there is no way. We had to come together, and she started to cry, and she got mad, upset, but she calmed down, and she did give me the impression that she accepted what I told her. Thereafter, we came down. Mrs. Yebes left the townhouse between 8 and 8:05 p.m. to attend a single parents' meeting sometime in Surrey. She took the two girls with her, and there's no evidence whatever of her presence in the townhouse after her departure until she returned at Yebes' request after the police had arrived and the bodies of the two boys had been discovered. According to Yebes' evidence, the boys were already in bed when his wife and two daughters left the townhouse at about 8 p.m. Tommy, the younger, was sleeping in the upstairs bedroom, which adjoined Yebes' bedroom, and Gabriel was sleeping downstairs on a mattress in a small utility room. The boys had formerly slept in bunk beds in the upstairs bedroom, but, according to Yebes, he found it necessary to separate them because they kept each other awake when together. Yebes said that when he went to bed at about 10 p.m. in the main upstairs bedroom, he said that he went to bed, he put on a stereo headset with a long lead running downstairs to the stereo set so he could listen to music while in bed. He went downstairs at about 10:45 to change the tape. He returned and after a while fell asleep, only to be later awakened by a noise. Thinking it was one of the boys going to the bathroom or one of the neighbors in an adjoining apartment, he went back to sleep. Aroused a second time by the smell of smoke, he went downstairs to see if it was caused by his pipe and found the room full of smoke. He went to the utility room where the boy Gabriel was sleeping and was able to push open the door. Inside, he saw the two boys lying on a burning mattress. They were covered and it appeared as if they had made no move to escape. He tried to pull one of the boys out, but upon reaching the living room, he noticed that the boy's body was stiff and lifeless. He then called the police. The police call was received by Sergeant Shaw of the RCMP at 1 a.m. on February 24th. He arrived at the townhouse within minutes of the call. When Shaw arrived, Yebes was at a window on the second level of the building shouting, "In here, in here." The police officer entered by the front door, which he found to be closed but unlocked, a fact presumably known to Yebes since he had made no attempt to open the door for the officer. The police officer immediately proceeded up a flight of steps to the second level and into the living room, which was filled with smoke. He at once saw one of the boys outside the door of the utility room. The boy was obviously dead. He looked into the utility room and saw the second boy, also dead, face down on the mattress. The mattress was still on fire with a noticeable flame. While the officer was making these observations, Yebes was on the telephone speaking to his wife. Shaw heard him say to her, "They're dead, they're dead." Another police officer, Constable Harrington, finally arrived, followed by firemen who extinguished the fire in the mattress. Harrington observed that Mr. Yebes was confused and detached. Mrs. Yebes arrived and spoke to Mr. Yebes for about 10 minutes. Following this conversation, Mr. Yebes was escorted by Harrington to a police car in order to make a statement. After making the statement, Yebes indicated that his hands and feet had been burned in the attempt to rescue the boys, and Harrington took him to a hospital for treatment. In the further course of the investigation, the police found a dry blood stain permeating the bedclothes on the upstairs bed where Tommy slept. Later, tests revealed that the blood was consistent with Tommy's blood type. They also found a damp stain in the bed. Sergeant Shaw thought it was urine, but this was never confirmed because the police laboratory was not equipped to test for urine. A butane lighter was found downstairs in the utility room. The lighter was opened in a position which allowed the butane gas to escape. The lighter sparked when first tested, but it did not produce a flame. It was then filled with butane from a container on the mantelpiece and tested again. It ignited immediately, producing a 6-inch flame. When the lighter was shown to Mr. Yebes, he acknowledged that it was his, but stated that it did not work for a long time. At trial, he explained that he had said this because the lighter leaked butane gas and normally became empty half an hour after filling. At trial, a fire expert, Mr. Hardman, was called to give evidence on the cause of the fire. He concluded that the fire had been deliberately set. He testified that the burn pattern on the mattress indicated that the fire had not started at a single location and spread. Rather, it had started at 3 separate locations. The burn pattern further revealed that the fire had been started using a flammable liquid accelerant, such as gasoline, paint thinner, or alcohol, although no container was found in or about the premises. Mr. Hardman was satisfied that the fire could not have been caused by the butane lighter alone. He also concluded that there was no evidence that the fire had been an explosive or flash fire. Further evidence clearly proved that the two boys were dead before the fire began. Fire tests were conducted in the utility room by burning a mattress under controlled conditions. These tests indicated that the fire of February 23rd would have produced large quantities of carbon monoxide, hydrogen cyanide, and soot within a few minutes of starting. A toxicologist examined samples of blood taken from the boys and found only minute traces, not exceeding normally expected levels, of carbon monoxide in the hemoglobin and no traces of hydrogen cyanide. He also tested the blood for a wide range of poisons and drugs and found none. An autopsy was performed on the two boys on February 24, 1982. The pathologist, Dr. Cave, examined the mouths, throats, and lungs of the children and found no evidence of carbon particles or staining. He also found no evidence of searing or singeing of the bodies consistent with death caused by a flash fire. Based on his findings and the findings of the toxicologist, Dr. Cave concluded that the boys must have been dead before the fire started. Although Dr. Cave could rule out fire as the cause of death, he could not determine the exact cause of death because of the condition of the bodies. There was no evidence to suggest that the boys had died of natural causes, and the circumstances alone seemed to rule out this possibility. However, Dr. Cave was able to state that the condition of the bodies was consistent with death by asphyxiation. Dr. Cave made an attempt to estimate the time of death by an examination of the stomach contents. He said that this was an imprecise method of determining the time of death, but, based on his findings, he considered it unlikely that the boys were alive 4 to 6 hours after their last meal. The evidence established that their last meal had been eaten at about 6:30 p.m., which puts the time of death not later than 10:30 a.m. and possibly before 10:30 p.m. When the police learned that the boys had not died in the fire, they immediately interviewed both Mr. and Mrs. Yebes. Mr. Yebes was distraught at the outset of the interview and became more upset as he described the discovery of the bodies. When the police officer, Sergeant Tilley, told him that the evidence indicated that the boys had not died as a result of the fire, Mr. Yebes completely broke down. Evidence was also led at trial of an event which occurred on February 7, 1982, approximately 2 weeks before the death of the boys. Mr. Yebes called the police that night and complained of a fire in the boys' bedroom, which adjoined his own room. When a police officer arrived, he found a candle on a plate in the bedroom and evidence that a fire had occurred. The boys explained that the fire had been caused by a monster who had been in the room. The officer examined the premises and found no evidence of entry through the doors or windows. He also examined the outside fence, which could have been used by an intruder to gain access to the bedroom window, but the new frost on the fence had not been disturbed. He concluded that the boys had been playing with fire and had told the tale of the monster to avoid reprimand. There is one further piece of evidence which should be noted. At trial, Mr. Yebes was asked whether or not he had locked his front door on the evening the boys died. Mr. Yebes replied that, while he could not specifically recall locking the door that night, he locked the door every night and therefore believed that he would have locked it that night as well. He was then asked whether he had unlocked the door at any time that night, and he answered that he had not. From this evidence, one would have expected the door to be locked when Sergeant Shaw first arrived that night, and more importantly, one would have expected Yebes to believe that the door was locked. And yet, when Shaw arrived, the door was unlocked, and Yebes appeared to know the door was unlocked since he made no move to go downstairs to let the officer inside. Instead, from the second floor, he simply shouted to the officer, "In here, in here." Yebes was charged with 2 counts of first-degree murder arising out of the death of the 2 boys. He was convicted of second-degree murder on each count before Justice Wallace and a jury. He gave evidence on his own behalf and adduced character evidence to the effect that he was a kind and affectionate father who appeared to be genuinely interested in the welfare of the 2 boys. Now, I'm going to stop here. I was going to lead more commentary later, but character evidence is extremely dangerous, and the reason why is because the Crown can't tender character evidence against you unless you put your character in issue. So once you put your character in issue, you start tendering character evidence, that opens the door to the Crown. And what can happen at that point is the Crown can then go and find anybody who's ever had a grudge against you to come into court and testify that you are a bad person and they don't like you and they think it's perfectly possible that you could have done this. So it's a really dangerous thing. The reason why that door to bad character evidence is normally closed is because prior to that rule, there was a practice where essentially, they'd find somebody has been murdered and they don't know who it is. So they'd just find the worst person in town and they'd bring them in front of the court. And then they'd have a line of people talking about how horrible this person is. And a jury would convict on that. A jury would quite happily convict on the basis of, here is this horrible person that the police think committed this murder. So that's why they close the door on bad character evidence unless it's put into issue by the accused, because otherwise it becomes really easy to falsely convict sort of troublemakers, but maybe not a troublemaker who committed this particular crime. So it is a dangerous strategy when you go and tender character evidence, but nevertheless he tendered character evidence that says, kind and affectionate father who appeared to be genuinely interested in the welfare of the two boys. The evidence also disclosed the efforts made by Mr. Yebes and his wife to adopt and care for the boys. Mrs. Yebes did not give evidence at the trial. An appeal to the Court of British Columbia was dismissed with one justice dissenting. The sole ground of appeal in the Court of Appeal was that the verdict should be set aside on the ground that it was unreasonable, or that it could not be supported on the evidence pursuant to Section 613 sub 1 sub a sub I of the Criminal Code. They followed the case of Corbett and the Queen and stated that the test under that section is whether the verdict is one that a properly instructed jury acting judicially could reasonably have rendered. He found that the verdict was reasonable, stating, although I think the jury could reasonably conclude that Yebes did not have a motive for unlawfully causing the death of the two boys in this case, I think also that the jury could reasonably conclude that regardless of motive, Yebes had exclusive opportunity to commit the crime. Motive is immaterial if the opportunity to commit the crime is shown to have been exclusive, and they cite a case of Imrich and the Queen. He further rejected the submission of counsel for the appellant that the Crown could not rely on the proposition of exclusive opportunity because it had failed to call Mrs. Yebes. Following LeMay and the King, he stated, and it's the King because it's a 1951 case back when there was a king. So, old case is the King, but it would still be R because that same initial, whether it's the King or the Queen. So counsel acting for the prosecution has a complete discretion as to what witnesses he will call, and that a court will not interfere with the exercise of this discretion unless perhaps it could be shown that the prosecutor had been influenced by some oblique motive, or so long as he exercises it fairly. Defense counsel did not at trial or on appeal suggest that in not calling Mr. Yebes or Mrs. Yebes as a witness, Crown counsel, influenced by some oblique motive, had exercised his discretion unfairly. Now, the problem with this is I don't think Mr. Yebes' argument here is that they had a requirement to do it, but just that the failure to call Mrs. Yebes might have left a gap in the evidence. So I'm not sure I terribly like the reasoning from that portion. Now I'm going to skip over a lot here because there's a big long set of discussion about what standard they're going to apply and the merits of each standard. And let's sort of jump more to the point. So these passages, especially the portions underlined, have led to some uncertainty regarding the standard of review to be employed under the section. And so essentially what they're doing is they go over a bunch of cases and they note that different cases have used different standards, which is why the Supreme Court is getting involved, although it looks like this was an appeal as of right, because there was a dissenting judge at the Court of Appeal. So, but this is why the court is so interested in this case, is that where there's this confusion in the law, the Supreme Court likes to try to stamp that out and make the law clear. So, as I've indicated above, the judges of the Court of Appeal were troubled by the apparent inconsistencies in these passages and attempted to resolve them. Justice of Appeal Hutchin, in dissent, concluded that the word possibly, used in the first passage, was inappropriate, and that the last of the quoted passages stated the law more faithfully. Justice of Appeal MacDonald, on the other hand, after citing the first of the passages quoted above, said with a hint of resignation, "So that is the definitive statement of the requirement of the subparagraph. I think that as a judge of this court, I should simply endeavor to apply it, leaving elaboration to the Supreme Court." I hasten to elaborate. this this is a little bit of dialogue between the courts where the Court of Appeal basically said, we're going to leave this to the Supreme Court because at this point they'd have known that there's a dissent, that they couldn't reach agreement. And so he says, the Supreme Court's going to sort this out. I don't need to go through a whole lot of stuff. And so Supreme Court is going to sort it out. They say, I'm in agreement with Justice of Appeal Hutchin. So not the one who said leaving elaboration of the Supreme Court. That the word possibly in this context is inappropriate. In my view, to adopt literally the proposition that the appellate court could only consider whether the impugned verdict could possibly have been reached would render review on appeal under the subsection almost impossible. So the debate here was whether it was whether the verdict could reasonably have been reached or whether it could possibly have been reached. And you can see how possibly is a really high test, because possibly just means it's somehow feasible that the jury could, connect the dots. But sometimes something can be possible even though it's way outlandish. So the court rejects the notion that the proper test is whether a properly instructed jury could possibly have reached the verdict, because that'll always be the case. And instead they go with reasonably could have reached must be the test. And from a reading of the whole of Pidgeon's judgment, I'm of the view that it was what was intended. The concept of reasonableness is clearly expressed in the section which speaks of an unreasonable verdict. Therefore, curial review is invited whenever a jury goes beyond a reasonable standard. In my view, then, Corbett is the governing case, and the test is whether the verdict is one that a properly instructed jury, acting judicially, could reasonably have rendered. So now the court has told us what the proper test is here. So I'm going to skip over a little bit more and then get to the court applying this test to the facts that we've just heard. So you can see how this gets applied in practice. Since there is no evidence in this case directly connecting Yebes to the death of the children, the question which now arises is, did the appellant during the relevant times have exclusive opportunity to commit the crime of murder? It is unquestionably established in the evidence that after the dinner at which Mrs. Yebes and her daughters were present with Yebes and the boys in the townhouse, Mrs. Yebes and the daughters left between 8 o'clock or 8:05 in the evening, leaving Yebes and the two boys alone in the house. There is no evidence whatever that she and the daughters or any other persons were present in the house until the entry of Sergeant Shaw at about 1 a.m. The medical evidence established that before the fire was started, the boys were killed by some human intervention, and that their deaths occurred not later than 12:30 a.m. and possibly before 10:30 p.m. The state of the fire in the mattress and the condition of the bodies upon the arrival of the police at 1 a.m. suggest that they died closer to 10:30 p.m. than 12:30 a.m. On that evening, the front door of the townhouse was closed but unlocked. Yebes' evidence was that he habitually locked that door when he went to bed. He couldn't remember whether he had locked it that night, but assumed that he had done so. He did not remember unlocking the door at any time that evening. Yebes testified that he did not give Mrs. Yebes a key to the townhouse, but that the key ring for his car keys held a key to the house, and on occasion Mrs. Yebes would have driven the car and had access to the key. There is no evidence as to where the key was on the night in question, but there is evidence that Yebes knew that the door was unlocked. When the police officer arrived, Yebes called to him from the second floor window, "In here, in here." The police officer entered the unlocked door. Yebes made no move to open it for him. There is no evidence of the presence of any other persons, save the two boys, in the townhouse that evening. Only the unlocked front door could raise a question as to exclusive opportunity. I am of the view that there was evidence before the jury upon which a properly charged jury could reasonably have reached the conclusion that Yebes had exclusive opportunity to kill the boys. I adopt the comment quoted by Justice of Appeal MacDonald to the effect that the reality of the situation is that only Yebes had the opportunity as well as the motive to commit the crimes charged. In my view, the first ground of appeal must therefore fail. The remaining ground, that the Crown failed to call a witness, Mrs. Yebes, essential to the unfolding of the narrative, must also fail in my view. The Crown has a discretion as to which witnesses it will call in presenting its case to court. This discretion will not be interfered with unless the Crown has exercised it for some oblique or improper reason. See LeMay and the King. No such improper motive is alleged here. While the Crown may not be required to call a given witness, the failure of the Crown to call a witness may leave a gap in the Crown's case, which will leave the Crown's burden of proof undischarged and entitle the accused to an acquittal. It is in this sense that the Crown may be expected to call all witnesses essential to the unfolding of the narrative events upon which the Crown's case is based. It is argued here that the failure to call Mrs. Yebes as a Crown witness was just such a lapse on the part of the Crown, and it leaves open an alternative rational conclusion to that of Yebes' guilt. It was argued for Yebes in this court that Mrs. Yebes had a greater motive than Yebes to commit the crime and also the opportunity. She should have been called to properly complete the narrative. So do you see what the argument is here? The argument here is that it could have been her. Maybe it wasn't him. Maybe it was her that committed the murder. So that's an interesting place to be going here. It's clear that these two are not in a sort of, they're not happy with each other anymore. And that's a pretty heavy, sort of issue. When you think about the facts we've read, you might draw your own conclusions as to what you think there. I've got my thoughts, but I'm going to leave them out here because I'm not a huge fan of getting sued overall. All right, so we see here, it seems to me that this argument is predicated upon pure speculation. So the court says, no evidence. It suggests that Mrs. Yebes should have been called to complete the narrative events which occurred in the townhouse that evening when there is no evidence whatever that she was present or possessed any knowledge of what occurred. The assumption that she had something to say to complete the narrative is not based on evidence and rests on nothing more than speculation. Now, remember here, who bears the burden of proof? Is it the accused? No, it's not the accused. The accused does not bear the burden of proof. So it's the Crown's burden of proof. The Crown should have to close the doors, not the accused having to open them. So that's a bit of an issue here in terms of my look at the Supreme Court's reasoning. Now, they're the Supreme Court. They outrank me. There is no question about that. But looking at this, I kind of have some issue about that because, to my mind, reasonable doubt can be based on a gap in the evidence where a reasonable person might say, well, what about this possibility? So long as there's another viable possibility on the table, that seems like it could be reasonable doubt to me. So, anyway, continuing on, what could Mrs. Yebes add to the narrative? The whole tragic history of these children and this family was put before the court by other witnesses. The facts leading up to the dinner on February 23rd were all before the court, as were Mrs. Yebes' concerns and attitudes, clearly expressed by Yebes and the other witnesses, including medical and social welfare officials. Her only contribution to the narrative would be related to what happened after her departure from the home at 8 o'clock p.m., and there is no evidence or any suggestion that she was present when the deaths occurred and would have any knowledge on that subject. In the end, all that she could have contributed was the bald assertion that she did not kill the boys. Of course, she could have been cross-examined on that. She would have given an account of what she was doing, and that could have been checked. They could have hit her with questions to say maybe that's not actually what happened, and put the suggestion to her. So, for the reasons given above, I would conclude that the majority of the Court of Appeal were not in error in their application of the section of the Criminal Code. They correctly applied the test in Corbett, and I would dismiss the appeal. So the result of this case is that they say the jury could have acquitted, but they reasonably could have convicted, so we're not going to overturn this finding. And, that's not a good verdict for Mr. Yebes because, of course, that means he's going to be stuck in custody. He's convicted and does a whole bunch of jail time. But there is a postscript to this story. And let's have a look at what happens some years later, because this was in 1983. And this is a new development as of November 6th, it looks like. Justice Minister orders new trial for BC man convicted of double murder in 1983. And that man is Thomas Yebes, the man who is the central figure in our case about unreasonable verdicts. And he appealed to Court of Appeal and the Supreme Court in 1987, but both were dismissed. 2019, he asks for ministerial review, and the minister concludes that a new trial is necessary. So, and if you're wondering why they did that, the reason why, from what I can tell from looking online, is that essentially a lot of the forensic evidence that was relied on has since been found not to be accurate, not to be reliable. It's a bit of a problem because, in particular, this sort of fire examination evidence has been found to be not very strong, not terribly useful. And one of the reasons for that, and this is just a bit about how this evidence sort of comes into being, how you get these experts. There's a lot of fields of forensic sort of science that come about because a police officer at some point or a fire investigator sort of notices a pattern, and they then decide that this pattern means something, and they continue on with that. And the problem is that isn't really good science, because in order to get something and to know it to a scientific sort of a fair degree of confidence, not only do you have to observe the pattern, but you have to test it. You have to test to see if that is always true, or if it's just sometimes true, how often it is, how predictable it is, and so forth. And that's a problem. So what we're looking at here is they have expert evidence that says, and I'm just going to look at a different article here. They said, I'm just finding it here. The jury was misled into believing that the boys were dead before the fire ignited and dismissed the presence of a lighter in the boys' previous history of fire setting, which strongly suggested the children lit the fire and died accidentally. Yebes was convicted based on invalid expert evidence that suggested he or someone set the fire to cover up the murders. Had a jury heard the new expert evidence that the boys may have been alive for a short period after the fire started, and that the possible time frames when the deaths occurred and when the fire was ignited were both quite broad, the case for homicide would have evaporated. So what does that mean? Well, does it mean he didn't do it? No, we don't know that for certain. However, with all of this information at our fingertips now, what it means is that he wouldn't have been convicted. It would have been a situation where they wouldn't have been able to prove it. And it appears that the most likely scenario here is that this was not a homicide, that this was, in fact, a very tragic event. And, that's really, it's messed up, because when you think about the timeline between 1983 or 1987, I don't know if he was out on bail pending appeal to the Supreme Court of Canada. So let's assume the latest timeline. Let's assume that he goes into custody in 1987. Well, it's 2020 now. That's a lot of years in jail for your adopted kids. And remember here, this is somebody who felt, terribly about the plight of poor children in another country and adopted them here to sort of give them a better life. And from the sounds of it, was doing his absolute best to advocate for these kids. If their playing with fire ended up if that was the cause of their death, then this guy, it's an absolute tragedy every way around. The deaths are tragic, but him spending that long in jail is tragic. And the simple fact is it kind of puts a bit of a stain on our judicial system, because the Yebes decision is one of the leading decisions on unreasonable verdict. And the Supreme Court says, this is a good verdict. Go ahead. It's good to send him to jail. And now, with the benefit of hindsight, we've seen that he shouldn't have gone to jail. He should have been acquitted at the time. So it's kind of a black mark on that case in a really big way. but that case is still a big deal. When I say it's a big deal, looking at looking at how many times it's been cited, it looks like it's been cited almost 2,500 times. That's a lot. Most recently, as recently as November 9th. So not that long ago. And I'm wondering, if future cases citing this are going to mention the elephant in the room here, which is that here's our test and it resulted in an injustice. Simply put, it resulted in what appears to be an injustice. So that's the case of the Queen and Yebes. I've been wanting to share this one for a bit now, but I've been sort of caught up in other things. It's a sad story, no matter how you slice it. But anyway, thank you for watching. I hope you found this to be educational. I can't say that you will have enjoyed it because it's an ugly story. But please like, share, and subscribe. And I also want to thank my Patreon supporters. At $50, George and D. Moe. At $30, Steve Browning. At $20, Kevin Fleet and Dale Nesbitt. And then at the $10 level, Ma Buddy Keith, as well as Process Eng. Stephen Larson, Mark D., General Counsel of the CCFR, John Robinson, Tim Rogers, Roy Haddock, Freckles Dack, Jean-Alexandre Tessier, Cameron Johnson, Sir Goat, Sights and Arms Limited, Chaba Hollow, Peter H., Craig Kwan, Akin Coxall, North Central Process Service, Toys R for Boys, Ian Vaughn, Milan Drakic, Terrence Griffiths, Doug Thompson, Brad Crooker, Jason Harrington, Lee Kiso, Mark Stout, Michelle Stotzel, Scott Sweetman, Mike Rhodes, Alvaro Bataille, DF, Stacey Cartmel, Tactical Advantage TV Canada, Ian S., Dave Leslie, Juan, Donald Duncan, Stephen Conquest, Darren Duell, Sean Crane, Ian Hutchinson, Rory, and Travis. And if you want to add your name here and test my lung capacity, there's a link to the Patreon below. I'm also going to leave a link to the case, as well as to a news article that follows up a little bit with the story of Mr. Yebes. As mentioned, this is a tragic story, and I feel it's kind of, as I said, it leaves a black mark on this decision and, to a certain extent, the justice system at large, because, I like to think that the Supreme Court should be getting it right, and they might have gotten it right in terms of what the test should be, but they certainly got it wrong in terms of, this particular circumstance. It's tragic. That's the long and short of it. And the main problem with this, the main reason why this happened, is because of bad forensic evidence. And I will go on a rant in a future video about bad forensic evidence. That probably deserves its own video about sort of discredited forensics. Anyway, thank you for watching. I hope you've enjoyed this, and I hope I've armed you with knowledge.